Did you have a question for Freya? All right, welcome back from lunch. It is 1:26 p.m. I see Mr. McClure is here. I believe we're recording, right, Freya?
Yes.
Okay, thank you. We are going to number 31 on the docket. That is 25892. Entries of appearance, please.
Thank you, Mr. Hearing Examiner Dina Bennett on behalf of Chevron USA, Inc.
Thank you.
There are no other parties.
I see that. Go right ahead.
Thank you. In this case, Chevron seeks an order pooling all uncommitted interest owners in Purple Sage Wolfcamp Gas spacing unit that's comprised of all of sections 19 and 30, Township 25 South, Range 27 East. And in the materials, we've included the usual exhibits, including the pooling checklist, the self-affirmed declaration of Katie Holly, who's testified before the division and her credentials have been accepted as a matter of record. The self-affirmed declaration of Hunter Birch. He's a geologist for Chevron, and he has previously appeared well, I've submitted an affidavit from him in the past with his resume. He might also be someone who, if we have time to qualify, that would be good since he will be a witness going forward. And he's included with his materials the usual suite of exhibits. And then I've included the notice materials, which include the notice letter dated January 12th and the affidavit of publication dated January 15th. And in reviewing the materials, I did note that the C102s that we provided look a little odd, and that's because these are actually irregular sections. I thought at first it might have been the optimization I went through, but the lines on the C102s are accurate. It's just that the sections are a little irregular. So with that, I would ask that the exhibits in case number 25892 be admitted into the record and that the case be taken under advisement.
Thank you. Admitted without exception. Mr. McClure.
Mr. Hearing Examiner, I have questions for the landman.
Okay.
Katie, Hallie, if you can turn your camera on and your mic, please.
Okay. Ms. Hallie, I see you, Ms. Hallie. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Would you spell your name, please?
It's Katie Hallie, Katie, and then Hallie is Halley.
Thank you. And you've previously been admitted as an expert before this division?
Yes, that's correct.
Good. In what field?
Petroleum land management.
Thank you, Mr. McClure. Go ahead.
Thank you, Mr. Hearing Examiner. Miss Holby, is it accurate that Chevron's requesting production supervision costs of $1,700 per well per month?
Yes, that's correct.
Okay, if I were to ask you to, or do you believe that that cost to be reasonable?
So the costs are based on our yearly review of actual drilling and production cost for the county of Eddy County. Basically, the costs are refreshed every April, and they comprise a average drilling cost for all the wells we drilled in the county, along with the average producing cost for all the wells that we produced in the county for that year from April to April.
Okay, if I were to ask Chevron to provide us with supporting documents demonstrating that the cost is reasonable, what would you propose to provide to the division?
So we can provide a methodology along with kind of a probably summary of the number of wells in the data set. I think beyond that, it comes from it, like, if you break it down further, then it would be on a well by well basis cost, which gets into the kind of proprietary area or confidential, which we would be concerned about providing because it would end up as public record.
Well, you understand that Chevron's requesting the division to force persons using state police power to pay these costs, correct?
Yes. We are happy to stipulate to 1,400 as the other companies instead.
Okay, that should be fine. Thank you, Mr. Hall, or Miss Harley, excuse me. Mr. Hearing Examiner, I have no more questions for the expert witnesses, but I do have some guidance for Miss Bennett.
Go right ahead.
Miss Bennett, on your CPAC, it looks like you intended to include the correct pool, of course, but it looks like there's a slight typo on the pool code.
Oh, yeah, I see it.
Do you need me to give you the right numbers, or are you good?
No, I know it.
Okay, and Miss Bennett, and we can bring on your geologist if you're not familiar with this next, but just to confirm, I'm also wanting to have the cross sections in the geologist exhibit to be updated to include the well API numbers. Do you understand what I'm asking for?
I do.
Okay, thank you, Miss Bennett. Mr. Hearing Examiner, I have nothing further for this case.
Okay. So let me just ask Ms. Bennett, how will you modify your exhibits?
I will be doing three things. First, I will be amending the compulsory pooling checklist to correct the pool code and to identify 1,400 as a supervision cost. Is this what you're asking?
I am. This is
Okay.
exactly what I'm
Okay.
asking. And then the last thing.
And then the second thing I'll be doing is amending the land man declaration to reflect the $1,400 supervision cost. And then the third thing I'll be doing is updating the structural cross sections to show the well API numbers.
I would be good on the first two things to keep the record open for the rest of the day for you to do those two things. I'm not sure about the third thing. Let me ask Mr. McClure. Mr. McClure, do you want to review the exhibit once the API numbers are included?
I mean, on that particular, I mean, we may be fine to go ahead. Your question, of course, is leaning towards taking it
Yes.
or leaving the record open
Yes.
for the end of the day.
Yes. Is that something you can do by the end of the day?
Yes.
Yeah,
Even
I
the
mean, if
API
you're-
numbers? Go ahead, Mr. McClure. I'm sorry.
Oh, the only thing I was going to say is if you're fine with the first two things, then I'm fine with the third one.
Okay, excellent. So we're going to leave the record open until 5. As long as you can get them in by 5 today, the case will be taken under advisement.
Thank you.
Okay, the next three cases, WPX Energy Permian 258939697. Entries, please.
Yes, William Zimsky, Abity and Schill on behalf of WPX.
Yes, Mr. Zimsky. There's no other parties in these three cases, and normally I would ask you to proceed. The problem is that the exhibits were filed late.
I was not aware of that. When were they?
I'll ask Mr. McClure. Mr. McClure, when were the exhibits filed? Or if you don't know, I can ask Freya. Who's better
Freya,
to know?
Freya
Freya.
probably has it off the top of her head. It's in her notes, but I could look
Perfect.
it for you too.
No, it's okay. Freya, what do you have?
I believe they were filed last Friday. The exact time I need to look up. They would have been due on Thursday.
Did you hear that, Mr. Zimsky?
Yes, I did.
So because of that, and because of the review load of this docket, these three cases have not been reviewed, so we can't proceed with them at this time. You can continue them to the March 5th docket and we'll review them at that time.
Yes, if we could move them to the March 5th, I would appreciate it.
By all means, you're more than welcome to go into the system and file continuances for the three cases. I think it costs about $150 each to move them, and then we will put them toward the beginning of the March 5th docket.
Thank you.
All right, thank you, Mr. Zimsky. Okay, let's go on to Hillcorp Energy 25898.
Good afternoon, Mr. Hearing Examiner and Technical Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant Hillcorp Energy Company, and I don't believe there are any other parties, so I'm going to jump right into it. So in this case, Hillcorp is seeking to pool the uncommitted interest in a 588.8 acre, more or less overlapping horizontal well spacing unit. And that is underlying lots 5 and 6, the east half of the southwest quarter and the southeast quarter. And that is the south half equivalent of a regular section 7. And then lots 7 and 8, the east half of the southwest quarter and southeast quarter, again, south half equivalent of irregular section 8. And that's in Township 32 North, Range 8 West, and that's San Juan County, New Mexico. And the pool involved there is the Basin Fruitland Coal Pool, and the pool code is 71629. And Hillcorp seeks to initially dedicate this spacing unit to the initial Trail Canyon 100 Federal Com 1H. I will let you know that our geologist has not previously testified, so we included his resume. Other than that, Rob Carlson, our landman, has previously testified. We've included all of the required exhibits, both for land and geology. And then that's followed by my notice, my self-affirmed statement of notice that was timely mailed out. The notice for the pooling, which was January 16th, 2026. We did send a follow-up letter to the BLM regarding the overlap, and that went out on January 28th, 2026. So that one is late. If we need to continue to perfect the overlap notice, we understand that. And then that's followed by the affidavit of notice of publication, which was timely on run on January 16th, 2026. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case be taken under advisement.
Thank you. Admitted without exception. Mr. McClure, who do you have questions for?
Quick question for Ms. Vance and then a quick question for the geologist.
The geologist has not been.
No, he
So
hasn't.
We're
We
gonna
get
have to get the
get him
geologist
a minute.
qualified. Why don't we do the geologist one first, Mr. McClure? Can we get the geologist on the screen?
Yes, he should be there. I was messaging.
Yes, I'm in if you can see me and hear me.
Not yet. Are you sure your camera's on?
Yes, sir. I can see it on my
I see you.
screen.
I see
Okay.
you. Okay, there
Perfect.
you are. Would you
Good
raise your right
afternoon.
hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. You can put your hand down. Would you pronounce and spell your name?
Vitaly Kuczynski, VITALY KUCHINSKIY.
Okay. Were you on earlier, Mr. Kuczynski, when I was admitting other experts in their fields?
Unfortunately, no, sir.
Okay. All right. So, Mr. Kuczynski, I don't, did you say that there is a CV here?
Yes,
Can
there
you put
is.
it on the screen for
Sure.
me?
Happy to do that.
Maybe I can just look at it. And Mr. Kuczynski, what field of geology are you seeking to be admitted as an expert?
Petroleum geologist, oil and gas, both development and
Perfect.
exploration. Yep.
Okay. All right. Did you, Mr. Kuczynski, I'm looking at exhibit D1. Is there any way to make this a bigger?
Sure, absolutely.
I don't mean the letters. I mean, no, that's not what I mean. Can you get rid of some of these toolbars so that this takes up more of the screen?
Yeah, sure. Is
I think there's a way of doing that.
that better?
That's better, I guess. I thought maybe, okay, whatever. Let's not get into this. Okay, Mr. Kuczynski, I'm looking at what has been identified by council as exhibit D1. Do you recognize this document?
Yes, sir.
Did you draft it?
Yes, I did.
Is it accurate?
It is accurate. Yes.
Do you have any changes you want to make to it?
No.
Okay, let me just review it. Can you make the CB go up now so I can read more at the bottom? Thank you.
The 2-page document, sir. Just, yeah,
I don't know that I need to review all 2 pages, Mr. Kaczynski.
sure.
The first page, I believe, is more than enough to qualify you. So, Mr. Kaczynski, from here on in, you're qualified as an expert in petroleum geology before this division. Mr. McClure, go right ahead.
Thank you.
Thank you, Mr. Hearing Examiner. Mr. Kaczynski, can you confirm for me that you believe each quarter section of this proposed unit will contribute relatively equally to the production of the well?
Yes, sir, that's right. The well's going through all this quarter section, so we believe all of them should contribute to the well performance. Yeah.
I understand they'll all contribute. Do you believe they'll contribute relatively equally to the well's production?
Thickness do change a little bit. It's obviously, there's a level of uncertainty with the pressure in each of them, but at this time, the thickness changes are not as significant, so I believe they should be equally contributing. Yeah, that's correct.
Okay, thank you, sir. Mr. Hearing Examiner, I have no further questions for the expert witness of this case, only Ms. Vance.
Go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Vance, what is your understanding of the notice requirements for overlapping spacing units?
That it's the same, the 20-day requirement. I'd have to go back and look at the rules specifically, but I think it's is it 12 for APD permitting? But I believe it's 20 days. That's why I said if we could just let it run that 20 days for the objection period, we're happy to, if obviously we need to perfect it, to then be able to let it be taken under advisement or,
Well,
to perfect it.
I was gonna say, I'm looking at the horizontal well rule, and I guess I wasn't referring to the notice period. I mean, the persons that need notice. And just a brief looking at it, it looks like it's the operators and working interest owners.
Yeah,
So I'm wondering, go ahead.
Oh, I was going to say, so the requirement, as far as what is required for notice, so the requirement is that it is for the existing spacing unit, either the operator, but if the applicant is the operator, then it would be the working interest owners. And if federal or state leases are involved, also those agencies, and then also to the working interest owners of the proposed spacing unit. But I believe we met that with all of the notice we provided.
Yeah, but you're referencing the definition for affected persons. Is affected persons the requirement under the horizontal well rule?
I'm not sure what you're asking. So or what we're trying to get at. So if you could maybe ask and or at least provide some. I'm not sure what we're trying to get at.
The definition that you just quoted is the affected persons from part 2. The horizontal well rule, where it talks about existing and subsequent wells and horizontal spacing units,
right,
is where it actually talks about the overlapping spacing units. And is that not the part of rule that
correct.
is relevant here?
Yes, and I'm there right now.
Does it require affected persons, or does it describe the persons that need to be noticed?
You give me a second. I'm pretty sure I just recited it, but
well, you recited the affected persons definitions from part 2, I thought.
No,
but,
I did not.
Okay. Well, it's more conservative to require the BLM to be noticed anyway, so maybe we're better off to let the notice period run.
Yeah, if you give me just one moment here. Yeah, I just repeat. Yeah, what I said is exactly what's in the rule. So the requirement is for the existing spacing unit, you provide notice to either the operator, or if the applicant is the is the operator, then you provide notice to the other working interest owners. And then if federal or state lands are involved, you provide notice to the feds or the state as appropriate. And then for the proposed spacing unit, you provide notice to the other working interest owners. Again, if federal or state lands are involved, you do that. That's not the definition of affected parties.
Okay, that's good. Thank you, Ms. Vance. Thank you, Mr. Hearing Examiner. I have nothing further.
Can we take this case under advisement?
No, the notice period needs to run to the BLM. Is that not correct, Ms. Vance?
Yeah, that's why
I
yeah.
thought you were saying that you had done that. That's what I thought that all that statement was about.
No,
No, okay. So you agree?
Because at the beginning of presenting, I said the notice for the overlap to the BLM went out on January 28th. And so it's not timely and we need to perfect that. So
When will it be perfected?
I did not do that math and I should have. I'm sorry.
And that's okay. March 5th, Ms. Vance?
Otherwise, I mean,
No, we can't do no more for February 26th. We're full. That docket is closed. So
Okay.
March 5th, Ms. Vance?
that sounds.
All right,
perfect.
sounds good. Thank you.
you.
Let's go to Longfellow Energy. This is 25903.
Good afternoon, Sharon Shaheen on behalf of Longfellow Energy.
Thank you, Ms. Shaheen.
Good afternoon, Mr. Hearing Examiner Yoditsa Pena on behalf of Spur Energy Partners, and we are just monitoring this case.
Thank you, Ms. Penn. You go right ahead, Ms. Shaheen.
Thank you. In this case, Longfellow seeks to pool the Yeso Formation underlying the north half of Section 33 in Township 16 South, Range 31 East in Eddy County, New Mexico. They propose to drill the Van Halen 33AB FedCom wells. That's the 1H through the 8H. We have in Exhibit A, the self-affirmed statement of landman Mr. Stuart Gaston. He has testified before the division and had his credentials accepted as an expert previously, and he has the usual exhibits, in this case, A1 through A6. In Exhibit B, we have the self-affirmed statement of geologist Jacob S. DeHammer, and he likewise has also testified before the division and had his credentials accepted as a matter of record. This is a standard unit with proximity tracks, and the 5H is the proximity well. Lastly, we have my Exhibit C, self-affirmed statement regarding notice. Certified mailings went out on January 14th, which is 22 days prior to hearing. And notice was also published on January 17th, which was 13 business days prior to hearing. And I'm happy to answer any questions. We have our landman and geologist available. But with that, I would move the admission of all of the exhibits and the sub-exhibits and ask that this case be taken under advisement.
The exhibits are admitted without exception. The case is taken under advisement. Thank you, Ms. Shaheen. Moving on to Permian Resources, 25904.
Yes, Jackie McLean on behalf of Permian Resources. And there's no other party that's entered an appearance in this case. Before we go to this one, can I ask just a follow-up question about case 25793?
Which?
That was, it was number 16 on the docket.
I'm there.
That one, we needed to provide tracking numbers. Is that something we have those and can submit those today? Can we provide those and the case be taken under advisement?
I don't know. Hold on one second. Mr. McClure, I don't remember what data you asked. I thought there was something else besides the tracking numbers, but I don't remember exactly.
For the Wolf Camp case, the other one, there was also the geology, but for this Bone Spring case, it's just the tracking numbers.
Mr. McClure, do you agree?
I agree. It's just the tracking numbers, but I'm going to want to review those.
Okay, thought I would ask
you,
because
Mr.
it wasn't
Appreciate
clear if we needed to
Okay,
continue that. Okay,
good try, Ms. McClure.
thank you. You never know.
No, you never know.
And case number 25904, Permian Resources seeks an order pulling all uncommitted interest in the Bone Spring Formation underlying a 1,257.31 acre non-standard horizontal spacing unit. And we have already gotten approval of the non-standard spacing unit under Administrative Order NSP-2336. Exhibits were timely submitted for this case last week and include the land testimony and geology testimony of Mark Haddock and Christopher Canton, who have previously testified as experts before the division. We also included notice testimony that shows that notice was timely sent to all interested parties on January 13th and an affidavit of publication for January 20th. With that, I ask that the exhibits be admitted for case number 25904 and that the case be taken under advisement.
Thank you. Admitted without exception. Mr. McClure, any questions?
Thank you, Mr. Hearing Examiner. I do have questions for the landman.
Would you call your land?
Yes, Mark Haddock, please.
Let's see.
I can see you, Mr. Haddock. I remind you that you're still under oath from this morning.
Yes.
Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. And Mr. Haddock, I'm looking at your exhibit A-4, specifically on page 104 of 163. And this is your table that it shows like the record title owner there.
I can share this too.
And also, I didn't hear you, Mr. Haddock, if you said something.
Pulling up, it was the question.
Well, just confirming that you were at the same. Are you on the exhibit that Ms. McLean is sharing with us now?
Yes.
Okay, and you see that table kind of in the middle of the page where it says record title? Is Permian requesting that the division force pool EOG Resources Incorporated?
Yes.
Was EOG
Hold on, Mr. McClure. Mr. Haddock, can you speak louder so that the transcript picks up your words?
Yes, we are.
Thank you, sir.
Mr. Haddock, was EOG Resources Incorporated? Do you know if EOG Resources Incorporated was provided notice of this application?
They should have been, but I'd have to.
I'll ask Ms. McLean if you don't know. That's fine. Mr. Haddock, if I can draw your attention to your commitment table in, Ms. McLean might beat me to it. It's A-7, I believe, page 143. Yeah, Ms. McLean has it in front of us here. Do you see your exhibit, Mr. Haddock?
Yes. Yes, I do.
Okay, do you see on there, like the bottom three names on that table where it says subject to JLA? You see where I'm referring to?
Correct. I mean, yes, I'm sorry.
I'm not sure if I'm understanding you, Mr. Haddock. What was it you said?
Yes, I see the column you're referencing.
Oh. You also see where it shows like Bowden and Blue Star is listed as being uncommitted.
That was probably a cut and paste error. That should be more committed. They're all subject to JOA.
Okay, so then Bowden and Blue Star should be committed on this exhibit. Is that correct?
Correct.
Okay, and if I asked you to amend this exhibit to correct that error, do you understand what I'm asking for?
Yes, we could. That's an easy fix.
It's really not possible to hear you, Mr. Haddock. If you could speak louder, closer, or get a different microphone because this isn't working.
Yes, I understand the desired correction.
Okay.
Okay, thank you, Mr. Haddock. I have no further questions for this expert witness, Mr. Hearing Examiner, but I do have some questions for Ms. McLean.
Go ahead.
Yes.
Ms. McLean, I'm sure you know what my question is going to be, but was EOG Resources provided notice of this application?
Well, I'm assuming because you're asking that they were not. And during the lunch break, what I found was we had gotten a second list that included the record title owners. And so there was actually a second date for notice, and we did not pool that second day of notice. So we have the tracking numbers and we can get those, but for some reason typing in the case number this time didn't get all of them. But so I'm assuming that it's not, I'm looking at this but yeah, we can do the same thing and get the tracking numbers. And we'll
Okay.
also amend exhibit or page 143, which is exhibit A6, or A7.
Yes, ma'am. And yeah, I was going to say, I mean, I guess we'll probably go towards, I'm assuming we're going towards March 5th. Otherwise, I was going to ask you what date that notice was provided. But clearly by March 5th, the notice will be cured regardless if it's been done by now. So.
Oh, yeah, it was the next day. So it's
okay.
plenty of time.
Okay, very good. Thank you, Ms. McLean. Mr. Hearing Examiner, I have no further questions for this case.
All right, so Ms. McLean, will you please continue this case to March 5th so Mr. McClure can review those tracking numbers?
And then there's also the
Yes,
page 143.
committed, uncommitted.
Yes. Okay.
Okay.
Thank you.
Yes, thank you. Okay, let's go to 25909. This is Mewborn Oil.
Mr. Examiner Dana Hardy on behalf of Mewburn Oil Company.
Go right ahead.
Thank you. Mewburn seeks an order pooling uncommitted interest in the Bone Spring underlying a 960-acre standard horizontal unit, non-standard horizontal unit comprised of the west half of sections 3 and 10, Township 26 South, Range 32 East, and the west half of section 34, Township 25 South, Range 32 East in Lee County, and will dedicate the unit to the Red Hills West Unit Com Wells. And Mewburn is seeking approval of the non-standard unit administratively. Our exhibits include the land testimony and exhibits of Ariana Rodriguez, who has previously testified and been recognized as an expert in petroleum land matters. We've also provided the geology testimony and exhibits of Justin Rodar, who has previously testified also and been recognized as an expert in geology. Our notice testimony and exhibits show that we timely provided notice on January 9th, 2026 to all of the affected parties. So with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Thank you. Admitted without exception. Mr. McClure, questions on this case?
Mr. Hearing Examiner, I'll have questions for the landman and then likely followed up with Ms. Hardy in regards to notice.
Okay, would you call your landman?
Ms. Rodriguez, are you available? She should be on.
Can you hear me?
Yes.
Yes, we can now.
Good afternoon, Mr. Rodriguez. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Would you put your hand down and spell your name?
Ariana, Ariana, Rodriguez, Rodriguez.
I recognize you. I've worked with you before. So go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Rodriguez, I'd like to draw your attention to your commitment table. Exhibit A-6, page 31 of 42. Oh, you're sharing your main screen, Ms. Hardy. I don't know if that matters to you.
There we go. What page, Mr. McClure?
Page 31. Ms. Rodriguez, do you see what Ms. Hardy's sharing in front of us?
Yes.
Okay, there's several persons on this table that's listed as uncommitted -- not pooled. Are those persons not committed?
Not committed yet, no. As of today, we had someone sign the JOA. So this has changed since then, but when we submitted this, that was correct. They were uncommitted, but we were not pulling
Do you know which person on here is potentially committed now?
them. Northern is committed now, and I think Northern.
Okay, thank you, Ms. Rodriguez. I have no further questions, Mr. Hearing Examiner, for this expert witness, but I do have follow-up in regards to notice to Ms. Hardy.
Thank you, Ms. Rodriguez. Go right ahead.
Thank you, Mr. Examiner. Ms. Hardy, was all these persons on this table, I guess with the exception of Norvin perhaps, provided notice of this application?
I
Well,
believe-
Norvin and Conchal, because it says Conchal signed a JOA.
So I believe only the parties who were being pooled were noticed. Yes.
Okay, so essentially like Great Western, Occidental, Devon, none of those persons were provided notice of this application.
Devon was noticed. If you look at page 42, they were noticed.
All right, give me a second so I can get there. I do see that. Then Oxy USA looks like they were noticed. I suppose an argument could be made about Occidental in regards to Oxy. So I guess the remaining player would be Great Western. Do you believe Great Western was provided notice of this application?
I do not believe that they were.
Okay, they're going to need to be provided notice of this application. And then Norvin, I guess, if they're committed now, we'll need this commitment table to be updated.
Okay, I understand that. Thank you.
Thank you, Ms. Hardy. Oh, I apologize, Ms. Hardy. I got one more piece of guidance. On your CPAC. Let me get scrolled up there. We have a lower bone spring that's being requested to be pulled here, and
Yes.
yet the vertical limit includes the entirety of the bone spring. So we're going to need to change that vertical limit to comply with that pull, or else add an additional pull.
Okay. And can you give me, I can consult with Mewburn. Can you give me, if we add an additional pool, can you tell me what pool that would be?
I can definitely get that for you. I don't have it in front of me. The only hesitance I would put out there is some of these cases are the cases that have been denied in recent history for having multiple vertically offset pools.
Okay, and so if the vertical limit were to change, well, can you give me that, what that change would need to be if we use the same pool?
Ms. Hardy, yeah, that vertical limit would now be, I mean, lower bone spring is fine. I can provide you better definition if you'd like, though.
Yes, please.
Yes, ma'am. The lower bone spring will go from the top of the first bone spring sand to the base of the bone spring formation. And it's fine to include that there. You can include that whole statement could be included in that field if you'd like.
Okay. Ms. Rodriguez, do you have any questions about that?
I think we have an email from the OCD I'm trying to look for where they confirmed the pools that we should be using.
Okay.
I haven't. I guess the question is what pool should be on there instead?
Okay, I think, Mr. McClure, we could follow up with you after the hearing regarding the polls if we have questions.
Does Mewborn wish to pursue multiple vertically displaced pools?
I don't know. I would need to consult with them about that.
Do you think your landman might know the answer to that if we bring her back?
Possibly. Ms. Rodriguez, do you know the answer to that?
Can you ask the question again? Sorry.
Yes, Ms. Rodriguez. Does Mewborn wish to request that the entirety of the bone spring be force pulled by the division, even considering that that would be multiple vertically offset pulls?
I think we're just in the second bone spring and the heart key.
And if I recall correctly, the Harkey is above the third bone spring sand. Is that correct?
That might be a geology question.
Yeah, the Harkey's not a New Mexico pull or formation.
I think it'd be the third shale, maybe. I'm not going to confirm that. I think that's a geology question.
Miss Hardy or Mr. Hearing Examiner, can we, I do have a question for the geologist.
Ms. Hardy.
Okay, and I believe Mr. Roeder had a conflict, so I'm not sure he's on, but I believe Tyler Hill is on and can answer the questions for Mewburn,
Okay.
or he should be on.
Yes, sir. Can you hear me?
Yes. Please raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Okay. Spell your name, please.
Tyler Hill, Tyler, Hill.
What is your field of expertise?
Petroleum geology.
Have you been so recognized by this division?
Yes, sir.
Okay. Mr. McClure, go ahead.
Thank you, Mr. Hearing Examiner. Mr. Hill, are all the wells being proposed by Mewborn in this unit, do they fall between the top of the first Bone Spring sand and the base of the Bone Spring formation?
Yes, sir, they do.
So is Mewborn proposing any wells within the Bone Spring formation that's above the top of the first Bone Spring sand?
No, sir.
So would it, for this proposed unit, would it hinder Mewborn if the region between the top of the Bone Spring and the top of the first Bone Spring sand were to be restricted and for that area not to be force pulled?
For this, no, it would not.
Okay, thank you, Mr. Hill. Ms. Hardy, I don't know if that gives you enough or if you need to touch base with your clients on whether you want to restrict your vertical limit or try to add an additional pool.
Okay, that does. I will consult with them. Thank you.
Okay, thank you, Ms. Hardy.
So, Ms. Hardy, March 5th?
So yes, we'll continue to March 5th.
Thank you. Got it. Let's go on to Enterprise Delaware, it looks like 25679.
Dana Hardy with Hardy McLean for Enterprise.
Thank you. Holland and Hart.
Good afternoon, Mr. Hearing Examiner. Adam Rankin on behalf of the Matador entities.
Thank you. Ms. Hunt.
Thank you. Let me just get to my notes. So this is a case that was heard previously and the examiners requested additional information from Enterprise. And so we did provide that. It's filed in the record. And if there are questions, Mr. David White is available to answer that.
Okay, thank you. So we will take your exhibits as filed, as corrected into evidence. And I see Mr. Phil Getz and I think Mr. Anthony Harris are both our technical examiners for the next 4 cases, or 5 cases, actually. Well, maybe 4, I don't know. So, Mr. Getz, do you have any questions for their witnesses?
Well, for the record, Mr. Examiner, I will take care of this case entirely.
Okay.
For Ms. Hardy, we did receive the package for the questions that Mr. Harris requested information on. He has reviewed it and this is deemed sufficient, so no more activity is required for that. There are two items I asked for, and I just wanted to see what the status of these items were. First, I asked to have some sort of description of what Matador wanted to see as a downhole deviation survey. Is there any specific criteria that has come in an agreement between Matador and Enterprise?
We are still working with Matador on that. I think the parties will reach an agreement, but we weren't exactly sure what Matador wanted and what you had intended. Is it the type of survey or is it a directional drilling plan? We weren't exactly clear on what you were looking to see.
Well, what we're looking to see is to have an anti-collision program provide, what we're looking for is where the well is and to where downhole conditions are. If Matador is going to come in with wells later on with horizontals, I would like to know where it is. So, and certainly we want to avoid any issues of having, shall we say, interception of well bores. So, and typically these are a more detailed survey, a more higher resolution gyro. So again, I would say to you, let's see some sort of agreement between Matador and Enterprise, and we'll make it a condition of approval. If that's the necessary path that needs to be done.
And we understood that that was an item that would typically be submitted with the APD. So is it possible to, issue the order and include that condition in the order? Is that what you're contemplating or?
Yes, this is after what has been proposed as a pilot dream, and then what is actually on the rocks is what comes afterward. So we will approach that as a COA.
Thank you.
So, Mr. Getz, I believe we can take this case under advisement.
One more, Mr. Examiner. I did have a requested an approach of resolution between NGL and Enterprise regarding case 16504 and NGL's application for the Cobra SWD #1. Was any headway made there, or is this something that the division will have to do on its own?
Well, I have spoken with Miss Bennett about that, and I don't know if she was able to reach her client, and I know she's not a party to this case. And I know the Enterprise also was reaching out to NGL, but I don't believe that they have made contact and been able to get a definitive answer on that pending 6-year-old permit application. So we're happy to continue doing that.
And
Mr.
Mr. Hearing Examiner and Mr. Getz, I apologize. I have not made any headway on that, and it's not Ms. Hardy's fault or Enterprise's fault. But I will definitely circle up with NGL in the very near term and see if I can get an answer.
Well, this puts us in a little quandary. Again, we can make this a condition of approval, but I forewarn you that if it is not resolved, it'll create a situation which has been becoming more common, and that is that this may be thrown into a commission hearing. So to that end, I sincerely support resolution of this without the participation of the division. And if division does end up calling the resolution of this 2 wells in the same area, essentially, be forewarned that this may impede any type of APD. So given that, I would go back to the examiner and say, yes, we can go ahead and take this under advisement.
Thank you, Mr. Getz.
Thank you.
And your reservations are noted. All right, we're off the record in this case. Let's go on to Select Water Solutions. This is cases. Now, one of these we're not hearing today. It's actually a contested hearing, but I'm going to call all four cases anyway. 25547, 48, 25899, 25900. Entries of appearance, please.
Dana Hardy for Select.
Good afternoon,
Hello.
Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Pilot Water.
Thank you.
Good afternoon, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon Energy Production.
Thank you.
Good afternoon, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating.
You know, I didn't ask the positions. Mr. Suazo, I know that you initially opposed. I'll leave that there. I didn't hear your position.
Yeah, and I'm sorry, I meant to say that. So previously we objected, Devon objected, and we've since withdrawn our objection and have an agreement in place with Select.
Okay, I'm sorry. I think I interrupted someone's entry. Oh, Ms. Hatley.
We are monitoring. We've withdrawn our objection.
Oh, very good. Thank you.
You're
Good
welcome.
afternoon, Mr. Examiner. Gina Bennett on behalf of Coterra Energy Operating in case number 25899 only, and Coterra is objecting.
Okay, and I think, isn't that the case that's going to a contested hearing?
It's currently set for a status conference on February 26th, but I imagine it will be set for a contested hearing.
Okay, so it's just a status conference right now. Thanks for correcting me. Okay, but that's just 25899.
That's correct.
Perfect, thank you. Any other entries of appearance?
Yeah, Mr. Examiner Matthias Sayer from Brad Butte Sayer on behalf of Desert Ram in each of the four cases, 5547, 5548, 25899, and 25900.
Thank you.
Opposed.
Thank you. Ms. Hardy, how do you want to proceed?
Well, we filed a motion to strike, as you know, Pilot's intervention and objection, which was granted. And this morning we received the order also striking Desert Ram's intervention and objection. So at this point, I don't believe that they are parties to this case, and there are no objections, and we are ready to proceed by affidavit, and our witnesses are available.
There have been several more documents filed. I think the certification says that you were served. I received them through the portal and I have reviewed them. So I think we need to talk about them. Now, have you seen them?
Yes, I did get them. One of them while we were here this afternoon
There's actually two of them.
I received a motion for reconsideration.
That's it?
That I have not had a chance to review because it just came in 30 minutes ago while I've been here.
Exactly.
And then I received earlier, actually just an hour ago about a sort of attempted amended notice of intervention with an affidavit.
I think the original document that Mr. Sayer filed in these cases was an entry of appearance and an objection. You moved to strike that. The response that he filed, was it late last night, Mr. Sayer? And I've read all of these documents carefully and studied them in depth. It changed it to more of an intervention as opposed to an entry of appearance. And if I'm putting words in your mouth, Mr. Sayer, I don't want to, and you'll have a chance to say what you want in just a moment, but this is from my perspective. So that's when I issued the order this morning, granting your motion. I issued the order granting your motion. Then Mr. Sayer filed a notice of intervention with an affidavit attached. It was the first time that he attached any evidence to his filings. I reviewed that carefully. Then he filed a motion for reconsideration, which had the same exhibit attached to it. Again, I reviewed that carefully. So I think we should discuss those documents. Why don't I let Mr. Sayer say a few words, Ms. Hardy, while you review the motion for reconsideration? I think that's only fair.
And I do think that Mr. Sayer did file a notice of intervention for Desert Ram yesterday or the day before. Pilot had only filed an entry of appearance.
Okay.
But Mr. Sayer had filed a notice of intervention. It's just now he's filed it with a supporting affidavit.
Okay.
Yeah.
So why don't you look at those two documents so I can hear from you? So why don't we approach it this way? Mr. Sayer, I issued an order this morning based on the documents that you had filed up until that time. Granting the motion to strike the intervention. Any way you want to look at it. In my order, I go through and outline why your client is not an affected party under the rules and why I believe your involvement, your client's involvement will not substantially contribute to this hearing. You then filed additional information. So why don't you take it from there and tell me why, let's just go with the motion to reconsider. Why do you feel like the self-affirmed statement of your witness would lead me to believe that your involvement would substantially contribute, which is the standard under the intervention rule, which I know you know.
Yeah. Thank you, Mr. Hearing Examiner. And at the start here, I'd like to recognize that, or at least acknowledge that, as you know, I dabble here in front of the division. And one of the things I've observed in my dabbling is that efficiency is appreciated. And so to the extent, I'm disrupting that efficiency, I certainly, recognize that and apologize for as much. The last 72 hours, I think I've been more than dabbling, and I apologize to Freya for the many filings. That being said, I just want to say real briefly regarding the notice of intervention, and there really is no substance there. You I think characterized it correctly. It was an intent to make clear on the record what we had intended to do when entering the appearance. We were trying to do that as an intervener, but making it clear on the record that that was what we were intending to do. So it is not necessarily a refiling of notice of intervention after, subsequent to your order this morning. Now turning to the motion for reconsideration, my read of your order, I noted that, there were some specific issues that the order kind of highlighted, that in my observation appeared to be perceived deficiencies in Desert Ram's presentation of its interests and injuries. So in the motion for reconsideration, we addressed some of those, specifically in paragraph 7 of the order. There's some recognition that we did not identify, groundwater wells, water right interests, et cetera. A lack of site-specific nexus, and then some discussion about how the division acknowledges and evaluates the groundwater issues. So in the motion for reconsideration, we've tried to address those items specifically. We've provided an inventory of water rights held by Desert Ram in the affected areas. We've also identified the specific points of diversion that Desert Ram owns and or operates to access those water rights. And then also attempted to highlight what we think is somewhat of a nuance to the kind of relationship between affected person as defined in the rules and the concept of standing and intervention as discussed in the rules. I think in the typical case, it makes a lot of sense that the affected party definition more or less is the scope and limit of standing. In this case, I think that there's a delta between standing and whether someone is able to materially or substantially contribute to the discussion about, in the statute and the rule, it talks about protection of correlative rights, prevention of waste, and then protecting the environment and public health, and leaning heavily on that last part, public health and environment. In this case, in the context of these shallow wells, these are, as you no doubt appreciate and read in the brief, or in the motion in response, they're relatively novel. The division approved 2 pilot shallow wells. Pilot, not necessarily, I'm not referring to the party pilot, but small p pilot project to Chevron in 2024. And now we have these 4 wells all within the same township. And I think 2 really relevant points to point to that, in my opinion, expand standing from the half-mile affected person definition and radius to a larger radius are 2 things in particular. One, in Select's own application, as you read in our briefing, they note that pressure propagation will be occurring as far away as 2 miles from the subject wells, and that's in each of the 4 applications. What we don't see in any of the applications is a combined synergistic analysis of the additive impacts of those 4 pressure fronts moving together and the pressure propagation occurring and resulting from those wells individually and collectively. And then second, and this is in the motion for reconsideration, if you look back at the commission's order in the Chevron matters, and I have those order numbers cited, there is discussion from the division. And I think it's worth noting, it was our good friend, Mr. Getz, who noted that the OCD had concerns for limited subsurface because of the limited subsurface information regarding faulting and fracture systems within the DMG. Now, note that the Chevron wells were in the Bell and Cherry Canyon formations. So, in terms of where we're at, these are the same formations. And the division noted that there was an absence of information. Nevertheless, what Select concludes in their application is they say that based on publicly known faults, there's no hydrologic connection. And Mr. Getz, on behalf of the division, said, we don't really know a lot about what's going on in these formations. So from Desert Ram's vantage point, it seems frightening to say that there's no hydrologic connection because we're telling you what based on what is known, there's nothing there, but what is known is very little. So that is at the kind of the crux of Desert Ram's position is we have water right interest. The wells are freshwater wells, while they may be, between 1 mile to 2 miles or around that area, that distance from the proposed wells, the aquifer we're drawing from is immediately beneath those wells. Desert Ram operates its ag operations across the entirety of 26 South 35 East, which is the township within which all 4 of these wells will exist.
Mr. Sayer, when you say directly beneath, I don't understand you.
Sorry, I should say directly above. The aquifer from which Desert Ram draws is above the formation in which Select would be injecting.
What is the boundaries of the aquifer that Desert Ram draws from?
You mean the depths?
Yeah.
That I don't know. And that's part of why, Mr. Hearing Examiner, why we're requesting as part of our motion and response a limited evidentiary hearing to be able to ascertain some of those things. The division doesn't know some of that information because they've acknowledged as much.
Okay. And are you aware of the depth that Select is requesting? What is that?
I don't know specifically. I'm not a technical person. I'm an attorney, but it's 4,500 feet, 5,000 feet.
Ms. Harding, have you had a chance to look at a motion for reconsideration?
I haven't read it in depth, but
I wouldn't think so, but what is your perspective?
so several things. This is far too little too late. These cases have been pending for 6 months. They were publicly noticed twice. And Desert Ram waited until less than 48 hours before this hearing to try to intervene. If they really cared and were paying attention, they could have raised these issues months ago. That's the first thing. So it's severely prejudicial to Select to have these issues raised at this late date. I think that the arguments that are being made still do not acknowledge that Desert Ram does not own an interest within a half mile. It doesn't even own an interest within 1 mile of these wells. And the division's area of review requirements and notice requirements are designed to protect interest that the division has determined in an appropriate radius that is based on technical information. It's not arbitrary. The division has set those distances. So there's a reason for that. But here they don't even own an interest within 1 mile. They say they own it within 2 miles. So that's way beyond the area of review in any of these cases that have been considered by the division. And that does not confer standing on them. In addition, the concerns regarding groundwater are addressed in Select's C-108s. Mr. Sayer has said that these are shallow wells and the water wells are the aquifers immediately above them or some in close proximity. Well, we've provided the groundwater analysis in the C-108s. There's a 4,000 foot separation between the base of the aquifer and where these wells are being drilled, and there are intervening confining layers. So the division also considers those issues when it evaluates these applications and is completely equipped to do that. So they have the information they need. If the division wants more information from Select, they can ask for that. But Desert Ram's belated participation based on an interest far outside the area of review for any of these wells is untimely. They don't have standing. It's impermissible. So that's my take on it.
Thank you, Ms. Hardy.
Thank you.
Mr. Sayer, I have some questions for you. Addressing the timeliness of this, what do you have to say?
Yeah, Mr. Examiner, and thank you for the question. Desert Ram is, as we all have established and acknowledged, is not an affected person. So what Desert Ram did not get was any notice. When Desert Ram learned of them, I reached out to Ms. Hardy, I believe 2.5 weeks ago, and said, hey, Desert Ram is concerned and intends to enter an appearance. In the intervening time, what we did is, tried to get our arms around this, again, because they're not an operator, they're an ag producer, they're not as sophisticated in the context of subsurface, dynamics. So it took a minute for Desert Ram to say, do we want to do this? We are very concerned. But again, we don't have geophysical, geospatial, geologic, hydrogeologic information at the ready. And so that's part of what we looked at. And so I guess the answer is they intervened when they found out about it.
Are you familiar with the C-108 that Ms. Hardy is discussing?
Yes, I am.
You are, okay. And did you review it?
I did.
Okay, when did you do that?
I reviewed it. I don't have a specific date, but probably multiple. Looked at it multiple times over the last 10 days.
How do you describe a C-108? What is it?
It's an initial filing associated with an application for a well of this nature.
Okay, and what is the purpose of a C-108?
To inform the decision maker, in this case, the division, as to what they're applying for and some basic parameters, information gathered to support the application.
And did you notice the 4,000 foot depth difference between the bottom of the aquifer and the top of the disposal area?
Ms. Hardy says that's what the number is. I'll take her word at it. I don't have it in front of me. But Mr. Examiner, I think super relevant to that point, which is, again, I'm going to keep pointing back to why we're asking for a limited evidentiary hearing. There are dozens and dozens of shallow wells just south and east of the New Mexico-Texas border. And each one of those wells presented similar information. Nevertheless, what we're seeing in Texas is surface uplift. We're seeing flowback of legacy vertical wells, and we're seeing contamination of groundwater. So I don't have that evidence here, but it's known. And that is the type of evidence we would like to present, because once this happens, Desert Ram has no recourse. If any of those consequences happen on Desert Ram's land, there's no recourse for that. You can't uncontaminate groundwater, and that's the water they rely on to sustain their operation.
Okay. I'm going to look here at your affidavit that you filed, and I will note that in your initial filing and then your response, there was no evidence presented at all for me to go on. Okay, so I just want to make that very clear. This is the first document that's sworn to, the self-affirmed statement of Jim Turco, the manager of the ranch. Okay, now, Mr. Turco, I don't, he's not with us today, is he?
Mr. Jerko, it's Tim Jerko, and he is not with us. He is actually out on the ranches right now.
That's fine. Who is Mr. Joseph Smith?
He is one of Select's witnesses.
Oh, very good, very good. Thank you. I wasn't sure who that was. All right. So he's the manager of the ranch. Okay. But he's not an expert in groundwater geology.
Correct.
Okay. He goes on to say that the water rights are actively exercised and essential to the ongoing agricultural and ranching operations. He asserts that they're legally protected property interests under New Mexico law. And then he gives me a list of information. Paragraph 6, Desert Ram's groundwater wells draw from a laterally continuous freshwater aquifer that underlies the township in which Select proposes to locate the 4 saltwater disposal wells and overlies the proposed injection wells. Now, when he says that the aquifer underlies the township, that doesn't tell me how close the aquifer is to the Select disposal site. It just says in general, and I would say vague terms, the location of the aquifer in relation to this project. Now, I know in other documents, I've seen that it's within 2 miles. But I'm not sure why he's saying that here. So I'm confused about that statement.
Yeah, and Mr. Examiner, I can attempt to add some clarity there. I think what he's trying to communicate is that the aquifer underlies the entirety of the township, while their specific fee and leasehold interest and points of diversion may be in location X, Y, and Z.
Okay.
The aquifer underlies the entirety of the
I
township.
could understand that. In other words, you mean something like the Oglala aquifer that goes throughout the entire middle of the country? Sure, I can understand that his rights are from a part of that. I understand that. 7, paragraph 7, based on Select's application and associated area of review materials, Desert Ram's surface lands, groundwater wells, and water rights are located within areas affected by Select's modeling pressure propagation, which Select's own reservoir modeling indicates may extend out to approximately 2 miles from the proposed wells over the life of injection. Paragraph 8, if pressure, migration, fracture, communication, or fluid movement were to occur nearer to the proposed injection wells, impairment within the aquifer would not be confined to the immediate vicinity of the wellbore. I don't know how he knows this. I really don't. I know how a ranch manager knows that. I don't find this helpful in making that connection between what he wants me to think and what I do think. I don't see enough here to change my decision. So I'm going to deny the motion for reconsideration and ask Ms. Hardy to present her cases.
Thank you, Mr. Examiner.
Mr. Examiner, can pilot be heard?
About what, Mr. Suazo?
Well, we just wanted to kind of make a few remarks for the record. And in the event that pilot's not allowed through council to appear in this proceeding, I have asked a representative pilot to appear to hopefully present to the division pilot's position through the public comment process.
Okay, so I'm not sure. Ms. Hardy?
I don't think that that's permissible or appropriate under the
Why not?
rules.
Why not?
Well, if it's not evidence, I haven't seen the division consider public comment of a party who was declined intervention status.
You know,
I
Mr.
suppose-
Suazo, just like Mr. Sayer, and I know Mr. Sayer knows this because he used to be deputy secretary here. If you disagree with the division's analysis and resulting order, you can appeal it to the commission. I just don't find that intervention by Pilot or by Desert Ram would substantially contribute to these proceedings, and neither one is an affected party under the rules. So I don't think it's appropriate at this point. I appreciate you offering it, but I just don't feel it's fair to Ms. Hardy's client. I have to give her due process just the way I need to give you and your client due process and Desert Ram due process. So I feel like I've done that. I've looked at all of your affidavits that you filed, because you filed many affidavits with your.
Correct.
Yes, and I've read every one of them carefully and analyzed them and researched them. And I feel very strongly about my decision not to let Pilot nor Desert Ram, for different reasons, intervene in this case. So thank you, Mr. Suazo, but I don't feel like your comment now would be helpful to this proceeding. So please, Ms. Hardy, let's get on, because we're going to have questions from Mr. Getz and Mr. Harris, et cetera.
I'm sure we will.
Mr. Examiner, can I just ask
Yes,
one
Mr.
follow-up
Sayer.
question?
Yes.
At risk of testing the examiner's patience, I wanted to just make clear that what we were asking for, and I appreciate as you read Mr. Jerko's statement that you still have some questions, which is exactly why our request was to put on, through a limited evidentiary hearing, some better refined, and, again, noting that Desert Ram is not, a sophisticated operator, an opportunity to present some of the evidence to answer some of the very questions that you're looking at. Mr. Jerko is not an expert, duly noted, but it's what Desert Ram has, and is asking for a small window within which to develop that evidence.
And Mr. Sayer, it's not that I have questions. That's not what I said before. What I said is I don't believe what you've given me so far rises to the level of the standard that this rule requires me to find before I can let you intervene in the case. And I believe I have a lot of discretion, and I have used that discretion in the past to let other parties, or not parties, but interveners, be involved in a case, because I felt like it would substantially contribute to protection of correlative rights, prevention of waste, and possibly the environment as well. I just don't feel like this is enough to get you there. And that's why I've asked Ms. Hardy to proceed. Go ahead.
Okay, thank you. So I can start with, would you like me to do one case at a time, or how would you like to do this? I mean, they're all different.
Let's leave that up to the technical examiners. Is it Mr. Harris or Mr. Getz who's going to be questioning the applicant here?
Yes, good afternoon. It's Tony Harris.
Okay, so Mr. Harris, would you like Ms. Hardy to present all three cases together, knowing that we have one case that is not being presented? And before I continue, when are you presenting that case?
That case is set for a status conference on February 26th.
And what do you propose to do with that case?
If an agreement hasn't been reached between the parties, then we would ask for a contested
And
hearing.
who are the parties that you are negotiating with now?
Kotera,
Kotera. Oh, Ms. Bennett.
Ms. Bennett's client.
Is that the only client right now that hasn't reached a resolution with you?
Yes.
Okay, so Ms. Bennett, hopefully you'll be thinking about a date in case your client hasn't agreed. A
Yes.
date for a contested hearing, and I'll want to have it soon, because these are August cases. They're old.
I understand that.
Okay, great. So, Mr. Harris, would you like Ms. Hardy to present all three cases at the same time?
Yes, please.
Okay, go right ahead, Ms. Hardy.
Okay. In case 25547, Select seeks authorization to drill and complete its saltwater disposal well, the Javelina, fed for SWD. The well will be located 408 feet from the south line and 831 feet from the east line of Section 4, Township 26 South, Range 35 East. Select proposes to inject an average of 15,000 barrels of water per day, up to a maximum of 20,000 barrels per day, and request a maximum surface injection pressure of 1,072 PSIs. This well was originally proposed to inject into the Bell and Cherry Canyon formations at a depth of 5,360 feet to 7,550 feet. But since the application was filed and Select worked with the other parties, we have limited the depth interval. It's been narrowed to 5,360 feet to 6,500 feet. So we have provided, and we have the same experts for each case. So let me go ahead and summarize the other applications as well, and then I'll summarize the experts. In case 25548, Select seeks authorization to drill and complete the saltwater disposal well called the Jackrabbit Fed SWD number 1. That well will be drilled at a location 556 feet from the south line, 1,968 feet from the east line, section 28, township 26 south, range 35 east. And that well will also inject into the Bell and Cherry Canyon formations. And similarly to the prior well, we have narrowed the injection interval. So now it is 5,305 feet to 6,500 feet. And that is reflected in our exhibits. And then finally, in case 25900, Select seeks authorization to drill and complete and operate the Roadrunner Fed 26 SWD number 1. That well will be located 2,561 feet from the south line, 2,086 feet from the east line, section 26, township 26 south, range 35 east. And that well will also inject into the Bell and Cherry Canyon formations, and those depths are 5,400 to 6,410 feet. So we have submitted for each case the C-108 and accompanying exhibits. Our C-108 is quite detailed and is supported by several exhibits. We have Mr. Reed Davis, who has previously testified before the division and been accepted as an expert in geophysics. We have Mr. R.J. Metzler, who has previously testified before the division and been recognized as an expert in petroleum engineering. Next, we have Mr. Thomas Tomastik, who has also previously testified before the division and been accepted as an expert in hydrogeology, injection wells, and petroleum geology. We have Mr. Joseph Smith, who has not previously testified before the division, and we have provided his information, his CV, and are asking to have him admitted as an expert in geophysics and geology. And then last but not least, we have Mr. David Childers, who has not previously testified, and we have submitted his CV and information and are asking to have him qualified as an expert in reservoir engineering. And then in each case, we've provided our notice exhibits, which show that notice was timely filed, sent to all the parties in all of the cases, and notice was timely published. And if you want the dates, I can give them to you. Given that these cases go back, some of them go back 6 months, notice was provided quite a while ago. But with that, I understand there are questions, but I would ask that the exhibits be admitted.
Admitted without exception. Okay, Mr. Harris, do you know which witness you would like to cross-examine?
Probably all 5. We can do it maybe as a panel.
Perfect. Who are can you call your witnesses? And Mr. Zimsky, I do see your hand up. I wonder if you can communicate with Freya about whatever concerns you might have, and she can let me know what they are, and I'll see whether we can come back to your case. Okay.
Thank you.
Okay, thank you, Mrs. Zimsky. And Ms. Vance, I know you want to talk about a case as well when we're done. I've asked Mr. McClure whether he can participate in that because I want him to be there. Okay, so let's see. I see Mr. Smith, Mr. Childers, Mr. Davis. I see 3, but I've heard that there are 5.
Mr. Metzler, Mr. Tomastik should be on as well. I see them.
I see Mr. Tomastik. One more.
Mr. Metzler. There he is.
Hmm? All right. Would you five gentlemen raise your hands, your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
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 Mr. Metzler?
Yes.
Good. I can barely hear you, sir. Can you speak louder or get closer to the microphone?
Yes, sir. How's that?
Okay, thank you. So let's see. First of all, I don't know why Mr. Smith turned off his camera. Mr. Smith, we're not done with you. Would you please leave your camera on? Thank you. I'll
My
start with you.
apologies.
That's okay. Mr. Smith, I'm going to ask each of you to spell your name and tell me if you have been previously recognized by this division as an expert, and if so, in what field? Go ahead, Mr. Smith.
Yes, my name is Joseph Smith, Joseph Smith, and I have not been recognized by this this body before.
You said you have not.
I have not, no.
Okay. And what do you seek to be recognized in what field?
Petroleum geology
Petroleum geology.
and geophysics.
Okay, so I'm going to come back to you, Mr. Smith. In the meantime, would you, I'm going to want a rundown of your education and your work experience. I'm going to
Sure.
want to hear some categories of like, when did you receive your degrees? Who were they issued by? What work have you done in this field? What is your current title? What are your responsibilities? Things like that, okay?
Okay.
All right, Mr. Childers. Would you unmute yourself?
My apologies. My name is David Childers, last name spelled Childers. I have not previously testified before this body before.
Okay, that doesn't tell me what field you seek to
Oh.
be admitted.
Sorry, for subsurface reservoir engineering.
Reservoir engineering, okay. Mr. Davis,
Yes, first name Reed, Reed, last name Davis, Davis, and I've previously been accepted as an expert in the field of geophysics.
so you have been previously accepted in which field, sir?
Geophysics.
Geophysics. Thank you,
Correct.
sir. Mr. Tomastik, I recognize you and I know that you've been recognized by this division, but please spell your name and tell me in what field.
Yes. Tom, Tom, and then last name is Tomastik, Tomastik. And I've been qualified as an expert in groundwater and in petroleum geology and underground injection.
Perfect. And finally, Mr. Metzler.
Yes, first legal name is Raymond, Raymond, Joseph Metzler, Metzler, commonly go by RJ. And I'm here to testify for petroleum engineering. I have not previously been designated as an expert witness with this division. I have for other regulatory bodies in other states.
Thank you, Mr. Metzler. So while each of you are listening to the other person give me their background, think about your own so that this can go a little quicker. We're going to start with Mr. Smith. Go right ahead.
Yes, I have a bachelor's and a master's degree in geology from Ohio University. I began my career 25 years ago with Occidental Petroleum, where I was cross-trained in geology and geophysics and petrophysics. And I have owned my own consulting company for a decade now. And I have worked the Permian as far back as 2004.
So you own your own consulting firm. What was the last position you held with the company?
The last position I held with the company was PDC Energy,
and I was their senior geologist for their Utica shale assets in eastern Ohio.
Okay, how familiar are you with our neck of the woods?
I kind of cut my teeth there. So I've done a lot of work on the Central Basin platform, on the Delaware, in the Midland Basin and the Delaware Basin. So I feel like I feel very comfortable with the geology there.
Okay, all right. Then we'll recognize you by this division as a petroleum geologist from here on in.
Okay.
Mr. Childers.
Yes, sir. My educational background is from the University of Oklahoma. I have an undergraduate in mechanical engineering, 2 master's degrees, one in petroleum engineering, one in geological engineering, and a PhD in petroleum engineering. I have been in the oil and gas industry since 2008. Overall, I've been practicing engineering since about 2003. I have most of my experience has been in midstream operations as well as subsurface reservoir engineering and saltwater disposal wells.
Who do you work for now?
Currently, I work for Select Water Solutions.
Did you say earlier?
No, I
I'm
currently
sorry.
currently work for Select. Yes, sir.
Okay. And how long have you worked there?
I have been here 2 years in June of this year.
Okay. What is your title there?
My title is Senior Reservoir Engineer.
Okay. You're accepted as a expert in petroleum engineering. And finally, Mr. Metzler.
Hello, Mr. Examiner. I graduated with a Bachelor of Science degree in petroleum engineering from the University of Texas at Austin. I've been employed at Select Water Solutions, previously Select Energy Services before we rebranded, my entire career, specifically working within the saltwater disposal world, across all lower 48 basins that we operate in, responsible for all technical support for all areas, downhole design, hydraulics, surface facility design. Currently, I serve as the Vice President of Operations and Engineering for the organization.
Okay. When was the last time that your title was petroleum engineer?
Specifically petroleum engineer, it has not been petroleum engineering as a specific title, sir.
Okay. When is the last time that you held a title other than vice president that involved the petroleum engineer specialty?
So through education, petroleum engineering covered a whole swell of activities within the industry. So you've got guys that are in completions, you've got facilities, you've got drilling, you've got reservoir, and they teach all facets of that engineering inside of schooling. I've covered every single one of them within the organization, and it all has all been held under the title of engineering, some type of engineering within the organization.
Okay. And when did you achieve the degree?
In 2014.
Oh, 14. Okay. And so since then, you've been working as a petroleum engineer in different aspects.
Correct.
Okay. All right. Then this division will recognize you as a petroleum engineer from here on in. Okay. Now that we have the witnesses qualified as experts in their individual fields, they will appear as a panel. Mr. Harris, you asked your question. Whoever wants to answer the question, just state your name and then give us your answer, because the transcript won't pick it up under your name unless you say your name. So go right ahead, Mr. Harris.
Okay, thank you, Mr. Examiner. Ms. Hardy, could we please open the case file or the exhibit package for case 25547, please, the Javelina. Thank you. And if we go to page 11, please. And so just for the record, I'll refer to this particular case file for all my questions. All the case files are very similar. The page numbers may differ slightly. But in this case, we're looking at section 3, which is entitled Well Data. If we move down to the second item, the casing information, at the very top of that table, it references the conductor casing, which will be 20-inch hole size. Just in terms of terminology and semantics here, oftentimes a conductor casing is the mechanism for cementing is they pull up with a ready mix truck and dump cement down the backside and call it good. I realize here you're mentioning that it's going to be the cement will be placed by circulation. Just want to verify that this will be a conventional cement job whereby your cement is pumped down the inside of the casing and circulated around to the annular space. Is that correct?
Raymond Metzler for Select Water. So it'll be pumped in circulation method, either by utilizing Tremie pipe running down the annular space between the casing wall and the borehole wall and circulated to the surface, or we would establish a casing nipple in order to inject down the internal of the well to circulate out the outside, but in all aspects, making sure that cement gets circulated around the outside. Yes, sir.
Okay, well, the OCD would have great reluctance with accepting the Tremie pipe. We would want to see what I would call a conventional cement job, whereby you run your casing with your float shoe and float collars, your conventional shoe track, and then pump your cement down the inside of the casing and circulate it out into the annular space and back to surface.
Yes, sir.
And that would apply for all cases under consideration here. Okay, thank you for that. If we could move to page 13, please. And referring to section 10, which is entitled Logging and Test Data. In the first sentence there, you've mentioned that the logs to be run include the gamma ray, resistivity, neutron density, and the sonic, and will be submitted to the division upon completion of the well. With reference to the sonic log, will that sonic log be run only for porosity determination, or will it also be used to get data on the in situ stress across the subsurface?
This is David Childers with Select. They would be also, I would be assuming that it would be both. We're going to look for both, looking at the stress and the incident stress, and understand some of the actual reservoir property, or I'm sorry, the geomechanical properties.
Okay, thank you. Yeah, because here, I mean, you're overlaying by the Salado, which is of concern because there's minimal separation between the Salado and your injection zone in the Bell Canyon. So we would want to see some mechanical properties data or some geomechanical data, either from a sonic log and also across the Delaware Mountain Group itself. It would be valuable to have sonic log information that can be used for geomechanics to infer the stress and frac gradients for each interval within the Delaware Mountain Group, so that you have containment both above and below. Is there any concerns with that request?
This is David Childers with Select. No, I don't think there's any concerns with that request.
Okay, thank you. If we could move to page 18, please. Okay, so we're looking at the wellbore diagram here. And we see that there's 4 different casing strings, including the conductor. I noticed that from below the base of your the underground source of drinking water, where your surface casing is set, down to the Salado, the intermediate casing string, we oftentimes see that there's a lot of issues with cementing, getting a good cement job across the Salado. Is there any consideration given to running multiple stage cement job here with deviation, or sorry, with DV tools or stage tools? Has any consideration been given to a multi-stage cement job?
Yeah, I'm sorry, Raymond Metzler, Select Water. We were for sure be analyzing and designing a DV tool for that intermediate section. We'll correspond with our geologist at what depth we need to set that whenever we get to drilling the, the well and through those formations through any of our analyzations that come back. So yes, we will plan to utilize DV or a two-stage cement job for that.
Okay, thank you. And also along the same lines for your production casing, which is the 7 5/8, just below the intermediate. Similar to the Salado, we also see a lot of issues with achieving good cement job and good cement quality across the Delaware Mountain Group. So likewise, would you plan to run deviation tools there as well, or sorry, DV tools and multi-stage cement job?
Raymond Metzler was Select. Yes, we could run a multi-stage job is there on that string too.
Okay, thank you. If we could move to page 19, please. And so we're looking at the SC2 retrievable packer. In the lowermost shaded section where it mentions advantages, so it says that the tubing and seals can be removed without accidentally unsetting the packer. So this is a retrievable packer, but do you intend to run an on-off tool here, or a polish bore receptacle assembly separate from the packer that will be stung into the packer?
Raymond Metzler with Select Water. It's very typical for us to run on-off tools in tandem with these packers. Yes, sir.
Okay. And then in terms of isolating from the reservoir, would you have, like if you had to pull the upper tubing section using your on-off tool, if you release from the packer, do you plan to incorporate any landing nipples below the packer to isolate from the reservoir?
Raymond Metzler with Select. Yes, sir.
Okay, thank you. If we could move to page 36, please. Okay, so this slide is entitled Reservoir Characterization of the Javelina, SWD number 1. If we look at section B, the upper confinement, if we read the first sentences, nearby open hole geophysical well logs indicate that the proposed Bell Canyon, Cherry Canyon injection interval is overlain by 1,000 feet of tight evaporates within the Salado, which will prevent upward migration of fluids and act as the upper confining layer. So just to clarify, you are stating here that the Salado will be your upper confining layer? There is no,
Tom
I guess, just to add to that one more, the Salado will be your confining layer. There is no Castile or no intervening layer between the Bell Canyon and the Salado?
Tom Tomastic, there may be some Castile within that, but the Salado Castile acts as a significant confining layer with evaporites that basically have low porosity and low permeability and act as a significant barrier for upward flow.
Well, I guess the OCD would take exception to that in terms of as a barrier or a confining layer, since the Salado does contain salt. We're injecting water, and salt is soluble in water, so we would view that quite differently. And so one thing we would request is that your uppermost perforation in the Bell Canyon be at least a minimum of 100 feet below the base of the Salado Formation. Would there be any concerns with that?
No.
And again, that would be a minimum of 100 feet. And we will require a cement bond log across the production casing here. And then depending on the results of that cement bond log, the top perforation, the depth of the top perforation may need to be moved even deeper. Would you have any concerns with that?
No.
Okay, thank you. If we could move to page 65, please. Okay, so we're looking here at the slide entitled Locations and Offset Logs. If you look at the very bottom left side of that slide, in terms of confining layers, it mentions the Lamar, the upper interval. Will there be any Lamar limestone present in this well, do you anticipate?
Tom Tomastic, you're saying, is there any Lamar present in these wells?
Well, correct. I'm seeing a conflict here because on the slide we just looked at mentioned that the Salado would be the confining layer, and here it's mentioning the Lamar.
Yeah, that probably needs to be corrected. That should be the Salado as the upper confining layer.
Okay. Okay, thank you. And if we could move just to the, I think the next slide, 66, I believe it is. Maybe 67. Yeah, so in terms of, I guess, the geomechanical properties, it looks like there has been some sonic logs run on some of the offset wells. Have you evaluated those sonic logs to determine, I guess, the stress gradient for, I guess, both the upper and lower confining zones from the offset wells?
David Childress Select, yes, we've actually looked back and evaluated some of those and tried to come up with some correlations to be able to kind of quantify what that is from those sonic logs.
Okay, but that information is not summarized in the application?
It is not, well, on the next slide, I believe there's where we used basically some fracture correlations later in the slides that basically tried to help kind of quantify what that range would be, but we have to go back and evaluate we're going to have to go back and maybe have to compile that information.
Okay, so I guess if we could go to page 69, I believe is the slide you're referring to.
Yes.
Yeah. So on page 69, which is discusses the fracture gradients, in the middle column, you have a table there that references the upper and lower confining zones. Do you see that where it says most likely fracture gradients of 0.726 and 0.771?
Yes, sir.
So was that determined from the offset sonic logs or any formation integrity tests or extended leak-off tests? How are those parameters derived?
Those parameters are strictly derived by the offset logs. We don't have any wells in this particular area that we could actually analyze for that type of data. And so what we did was just utilize the fracture correlation model to kind of get a good idea of what the minimum and the upper limits might be, and then run some triangular distribution to be able to kind of come up with what the most likely fracture gradient would be. We will know more once the well is actually in place and we can do testing.
Okay, so then I guess there is value in having a sonic log to characterize the stress for your upper and lower confining zones. Is that fair to say?
Yes, that is.
Okay. Thank you very much. I have no further questions. We do have Ms. Stacy Sandoval who has some questions in this case.
Go right ahead.
Let me unmute. I'm going to be referring to pages in case 25900. If we could please pull that case up. Okay, so my first question is on page 12. So looking at the last paragraph of section 8, geologic description, you mentioned the Rustler Formation, but there is no mention of any underlying sources of drinking water beneath the proposed injection interval. For clarity, did you not identify any underlying sources of drinking water beneath the proposed injection interval?
This is Reed Davis. I believe there's a no hydrologic connection statement later in the application that addresses such. It should have been included here. That was an oversight.
So I saw where you're mentioning the Rustler, but I didn't see where it directly stated that you did not find any underlying sources of drinking water beneath the proposed injection interval. So I just wanted to make sure that
This
that
is
was true.
Tom Tomastic. There is no deeper USDW below the Rustler Formation. The Rustler is the deepest underground source of drinking water in this area.
Okay, thank you. And this applies for all three of the applications that are being heard today, correct?
Yes, that's correct.
Okay, I will move to the next question on page 34. So under section C, lower confinement, on paragraph 1, you state that the lower confinement is the low porosity and permeability rocks within the Cherry Canyon Formation. But then on page 63, under the confining layers, you listed the lower interval of the Brushy Canyon. So can you just please clarify what is your lower confining layer for these proposed SWDs?
Yes, Tom Tomastic. If we can move to the page 30 or 6, the next page below that, please. Page 35, I guess. So we're looking at confining layers that are directly below the proposed injection zone. So we would consider the lower confinement as being those low porosity, low permeability zones that are developed within the Cherry Canyon. So we could amend the other page to reflect that.
Okay, thank you. My next question will be on page 75. So this is looking at the self-affirmed statement of Thomas Tomastic. My question applies for cases 25900 and 25548. So referencing paragraph 9. Mr. Tomastic, I'm just wanting to clarify that your statements in this paragraph are the same findings and confirms the statement made by the consulting geophysicist and geologist Joseph Smith that he stated on page 43.
Yes, Tom Tomastic. That is correct. This paper that was published in 2019 within the Delaware Mountain Group study, it is in Texas, but with the similar geologic environments. This clearly shows that the shallow graben features in the Delaware Mountain Group are associated with likely fracture systems that are related to evaporite and carbonate dissolution figures from the Salado Castile. They are not consistently across the area, but seem to be mapped in about 1.5 to 2 mile areas. In review, and Mr. Smith can go into more detail in a review of the seismic sections, which we ran 2 miles across, both north and south, east, west. We have not identified any of these graben-related vertical fracture features in the DMG. And there is a very good example in this paper showing what the graben feature looks like in 3D seismic.
Okay, thank you. I did notice for case 25547, there was no statement by Joseph Smith, like in these other two cases. Is there a reason why that was not included in that particular case?
This is Joseph Smith. I'm not sure why. Maybe it was just an omission.
Okay, so it should have been in that case as well.
Yes.
Okay, thank you. And then if we go back to case 25900, page 106. So if you scroll down, please. So the delivery status for the McCombs Energy Ltd says in transit to next facility, arriving late. Do you have an update on whether they've received this packet? by any chance?
That would be a question for me, Dana Hardy, since I send out the notices. And I don't have an update. We can see if we can get one, but sometimes companies are out of business, not locatable, and I don't know what the situation was with this one, but we can check and see. We did timely publish notice, so there was public notice given in case parties did not receive the actual certified mail notice. But I can double check on that status.
Okay, thank you. My last is just a comment, so it'll be for all three SWD applications. We would like to see an induced seismicity risk assessment, with these SWDs being between two seismic response areas and seeing earthquakes to the south. We would like to see an induced seismicity risk assessment for each SWD well being proposed. And an example of some things we'd like to see is an evaluation of potential communication with the Precambrian through faulting or other geologic features, looking at earthquakes within 10 miles of the proposed wells, and a statement on, potential for induced seismicity as a result of injection of produced water into these wells, et cetera, just for some examples. Would that be able to be provided?
This is Reed Davis, and yes, we can provide that for each of the wells.
Okay, those are all my questions. Thank you.
All right, thank you. Ms. Hardy, did you catch what needs to be submitted?
Yes, I believe we did.
Do you want to just go over the list so that Mr. Harris and Ms. Sandoval can hear that you have everything?
Yes, so I understood just now the induced seismicity assessment, which we will provide. The other items, I guess Mr. Smith's statement, if that was omitted from one of the cases inadvertently, we would include that. The questions about correcting whether the confining layer on page 65 should be the Salado or the Lamar, and we would correct that to be the Salado. On page 34, clarify the lower confining layer. Yes, I think that hopefully my witnesses understood the questions as well. So I'm not a geologist or an engineer. And some of these there were questions about, but I'm not sure if the examiners actually wanted supplemental information.
Okay.
So those were the items I had.
Okay. Do any of the witnesses have questions about what the examiners are asking for?
This is Tom Tomastic. I can go through what I've jotted down, I believe. The request from OCD was the usage of DV tools and I'm assuming an external casing packer on the intermediate production casing. We need to have at least 100 feet of separation from the base of the Salado to the proposed top perforation. And based on the CBL log, we may need to move that top perforation even deeper. And then I had page 65, replacing the Lamar with the Salado as upper confinement on the sonic logs, to be used both for porosity and frac gradient data calculations, and then amending the lower confinement on the one, I think it was page 34, where we had the Brushy Canyon, to change that to the Cherry Canyon zones, and then the seismic evaluation, and then Mr. Smith's statement omitted. That's what I had written down.
All right, well, Mr. Harris, anything before we go into recess on this case? Because I'm not sure when it's coming back. I guess it depends on when the witnesses can give us the information and you can review it.
Sure, yeah, nothing else from my side.
All right, wonderful.
And I did
Okay.
confirm quickly while we were just in this meeting, I did confirm the status of the mailing to McCombs. and it's still in transit. So I don't know why that would be,
Now,
but
we're coming back on the record on the 26th, and we have offered you the March 20. What date was it in March for the contested hearing for this other fourth case?
March 24th, I believe.
Okay, I believe you're right. Hopefully at the status conference, you will have conferred with your witnesses, Ms. Hardy and Ms. Bennett, about March 24, so we can issue the pre-hearing order and get that case moving along. We will also have these technical advisors at the March 24 hearing. So maybe it's at that time when this other information can be submitted and reviewed.
Let me ask my witnesses how long it would take them
Okay.
to assemble the information that's been requested.
This is David
Tom
Chil-
Tomasic. I don't think it's going to be too hard to assemble this.
If we could have it heard, I don't know if the examiners are available anytime before March 24th.
Maybe March the 5th. Mr. Harris, Ms. Sandoval, would you be available to look at this new information and be prepared with any follow-up questions on March 5th?
Yeah, absolutely. And
Yes.
if the companion case is being heard on the 26th, we could probably do it then.
Okay, so the companion case is coming for a status conference, so that normally we don't have technical examiners at status conferences, but if you don't mind to be available on the 26th of February, then we could do that then as well.
That works for me.
That'd be great.
Okay, so we'll try for the 26th of February, but for some reason, if your witnesses don't get the information together, you have a backup plan for March 5th.
Understood.
All
Thank
right.
you very much.
All right, then thank you, Ms. Sandoval, Mr. Harris, Mr. Getz, and all the witnesses
What?
for
One more item, Mr. Examiner.
Go ahead, Mr. Getz.
Could I? Sorry to interrupt, but I have one more task for Ms. Hardy. In the case of, let's see, the Roadrunner, that would be 25900. Would you please send a copy of the application as a notice to the city of Jowell, please?
Absolutely.
Other than that,
if I
nothing
could-
else.
And Tony Harris here, if I could add one more item. For the February 26th or whenever we hear this again, I would recommend that they just submit a supplemental exhibit package, not an entire, there's no need to update the entire application. Just simply submitting the supplemental package, which would be, 5-6 pages to address the items.
Perfect. We will do that. Thank you.
Okay, thank you.
All right, thank you all. Okay, we're in recess on these cases. Was there anything else before we go off the record? Ms. Bennett? No, on anything.
Yes, you were going to recall my Avant case and Coterra cases.
Forgot that. Okay, are you talking about 25748?
That's the first case, yes.
All right, that's number 11 on our docket. Why are we recalling it?
In that case, Mr. McClure identified some issues with the the lower Wolf Camp. And I had mentioned to him and to you that I would confer with Avant to see how they would like to proceed. And Avant would like to maintain its application for the 721 and 723H wells, which were in the correct pool, and dismiss the remaining wells, which are the 801, 802, 803, and 804H. And we would ask that the division take this case under advisement without requiring any new submissions.
Mr. McClure, are you with us?
Yes, I am, Mr. Hearing Examiner.
And did you hear what Ms. Bennett just said?
Yes, I did, and I'm just looking at my notes. Ms. Bennett, did we ask for any other documents to be submitted other than GEOL for the 800 series wells?
No, you did not. The only thing that you had asked was to amend one of the lower Wolf Camp exhibits to show the top of the Wolfcamp D, but that would be rendered moot by Avant's dismissal of the 800 series cases.
Mr. Hearing Examiner, I think the only thing we would need then is for the CPAC to have some wells removed from it. Perhaps discretionary for allowing them to do it by the end of the day. I don't know what your thoughts are on the matter, though.
Ms. Bennett?
Thank you. I am happy to remove the wells from the CPAC. The reason why I'm a little reluctant is I don't want to have to go through every single exhibit and remove those wells because they do appear, for example, in the land exhibit and they appear in
What if you do this? Then I have an idea. Sorry to interrupt, but it's late in the day. Why don't you file a motion? File a motion with the division saying, please dismiss that part of our application. Then we have it on the record. And then Mr. McClure knows that you're not interested in it anymore. You don't have to revise each exhibit. Is that okay with you, Mr. McClure?
Yeah, Mr. Hearing Examiner, I'd be fine with that, but we would need them to give us the new CPAC, even if they don't update the other.
Okay. Because it's an exhibit. It's an exhibit.
Yeah, well, because it'll be a part of the hearing order. Yeah.
Okay, all right. So why don't we do this? We'll leave the record open until tomorrow at 5 p.m.
Okay.
That'll give you a chance to file an order with a motion with a proposed order dismissing your 800 wells and also attach the corrected CPAC.
And when I attach the corrected CPAC, should I attach that to the motion to dismiss or shall I file a revised exhibit packet?
Mr. McClure?
I mean, it's probably better practice to have her just give us a new exhibit packet unless you think that'll be problematic, I guess.
I don't think it would be. Yes, so
Yes.
So an amended exhibit packet with the corrected CPAC. That way we can take the old exhibit packet out to remove any confusion there. And we'll have the order in there dismissing the cases. Sorry, not the cases, the wells 800s. Okay?
Yes, thank
All
you.
right. Are you done now?
No, I'm not.
Okay, what's the other case?
25805, please, which is
805?
yes, the Coterra Eastwood. It's number 18 on the docket.
18. Okay.
I'm sorry, 18. Yes, 18 on
All
the
right,
docket.
let me recall 25805. What are we coming back for?
In this case also involves two sets of wells, Wolfcamp wells, upper and lower. And in this case, Coterra would like to move forward only with its upper Wolfcamp well, which is the 404 well. But the current 25805 case was a standard unit because there was a proximity tract well. One of the lower Wolfcamp wells was a proximity tract well. When we dismiss those wells, that means that this becomes a non-standard unit. And so what I would really love, like more than anything, is if I could file an amended application tomorrow that could be heard on March 5th, recognizing that there's not quite 30 days, but the division has allowed some flexibility there, so that I could amend it to A, remove the other wells, B, request non-standard unit approval, and C, still come to hearing on the 5th and hope for an expedited hearing given the lease expiration issues. And of course, I would address all the other things that Mr. McClure asked me to fix in both this case and case 25806.
Mr. McClure?
I mean, I don't have an issue with that, provided that it doesn't cause us problems on our notice, which I'm assuming we haven't noticed February 5th docket yet or March 5th docket yet.
We have not.
We have not.
Okay, I mean, I don't see an issue as long as all of the notice can be met by that time.
Okay, yeah, I'm willing to adjust the 30-day rule so
Thank
that
you.
you can file an amended application tomorrow. We can notice it properly and we'll hear it on March 5th.
Thank you.
You're welcome. I'm hoping that's it. All right, thank you, everyone. We are, thank you, Mr. McClure, really, thank you. We're off the record.
Okay.